Hello and welcome to Taking the Stand, a fan podcast production. And in today's episode, Ben and I from the Fan Justice Project are going to take a deep dive into PEPUDA and what that means for South Africa. Now, what is PEPUDA, you may ask? Well, it is the shortened name for the Promotion of Equality and Prevention of Unfair Discrimination Act of 2000. It is about, equality. At least that's what the Act claims. And Ben and I have some questions as to equality and changes to this Act and the way the government is approaching those changes. For a bit of background, PEPUDA is this piece of legislation that's now almost 20 years old, more than 20 years actually, and it is about, equality, and that's supposed to be a good thing, right? And it's got a noble intention, and protecting people against unfair discrimination all sounds good. But today, in this short podcast that we have here, Ben and I will delve into a few problems with PEPUDA. So, Ben, let's take the first thing that I think people should know about and where the PEPUDA changes now on the cards fall short, and that is in this thing called public participation or public comment. What are your thoughts on that? And give us a bit of background as to why this is an issue for these changes to PEPUDA.
Okay, well, first of all, public participation is a crucial element of our democracy. It allows the public to voice their opinions and their thoughts and their concerns about any piece of legislation that comes before us. So this sort of crucial element was outlined in a seminal case called Doctors for Life, where they laid out just how important this is for a functioning democracy. So now, where that fits into this PEPUDA amendment bill that we're talking about, on the 31st of March, the department said, all right, guys, here's the amendments for the PEPUDA bill. There's 6 weeks for the public to comment on it. And now there were some really big changes, which I'm sure we'll get into at the end of this podcast. So a couple of interested parties, like the IRR, said, we don't think that 6 weeks is enough time for the public to comment on this bill, and we think there should be an extension. Now, what the department did was they only allowed an extension for specific parties who asked for it, and not a general extension. So we thought that was procedurally unfair and quite ironic, because the bill purports to promote equality, and what they did there was saying, all right, only some parties can have an extension on the bill, but not the general public. So we highlighted that as quite ironic and quite unfair. And we've written to the department on, I think, 3 occasions, asking them about this procedural irregularity, as well as a socioeconomic assessment for this bill. So yeah, that's what we've done at the Fan Justice. Herman, what more would you like to add to that?
Well, I think that's such a good segue to this element of watchdog legal work, where we need to make sure that freedom is protected by the proper functioning of democratic and constitutional mechanisms. On the one hand, a very key element of getting new legislation or new changes to existing legislation is public comment, exactly as you say, Ben. But the other part that is really, really important is what we call socioeconomic impact assessment studies. That's essentially where the people responsible for proposing a bill looks at the social consequences, how will communities and people be affected in their daily lives, but also the economic consequences. What will this cost whom? What will be the benefits? What will be the risks? And these things then get published in what is called a socioeconomic impact assessment study to make sure that people looking at the legislation and all interested parties, that should be all South Africans when it comes to laws, understand what are the consequences of this bill, because we all know legislation isn't just some theoretical thing that happens somewhere in Parliament. It has significant changes in store for our lives socially and economically. And we saw the other day an example of a socioeconomic impact assessment study on expropriation without compensation, the amending of Section 25, the property clause of the Constitution. And I must say, it was such a travesty. It was really, really just a shoddy piece of work. And the people at Sakelicha did immensely well in publicizing that and showing how really impoverished and poor this quality of legal work is. So when it comes to, as it were, the first preparatory steps of getting the information that needs to be out there, and getting the feedback, the department has fumbled on both of these. And we've written to the department to lay the groundwork for possible legal action later. These things take time, and you have to be strategic and tactical about it. You know, when do we apply which bit of pressure to make sure that at the end of the day, if we need to build an aggressive, strong legal case, we've got what we need. And what we've written to the department saying, you know, firstly, how can you take this unequal approach, saying to some people they have a longer period, but not making it clear to the public? Very, very dodgy, a bit secretive to have this case-by-case ad hoc approach to the extension. And then, of course, the second issue is no socioeconomic impact assessment study of any kind that we could find saying, you know, if this happens, the socioeconomic consequences. And it's important on the Doctors for Life precedent, and also just in general, to make sure that procedures are stuck to, because democracy isn't just pitching to vote every 5 or so years. It is also making sure that when changes come during those, elections, people have the right to have a fair input on these matters. And Ben, I think we wrote the third letter earlier today. We sent it earlier today as it were the third step in our process of stepping up pressure on the government to do this thing correctly, to take the process seriously, and perhaps give us a bit of a glance into what's in this third letter and why do you think it's important?
So in this third letter, we just really make the point of how important public participation is. And I think it's important for people to understand that democracy it's not a snapshot in time, it's an ongoing process. So like you said, you don't just rock up once every 5 years and vote. You've got to be you've got to be intimately involved in the process for laws that affect you. We also so that's basically what our bill our letter today was really drawing attention to.
And if you say, you know, the consequences for people who should be intimately involved because there are consequences here, let's take a moment to look at some of those consequences. I know you've got a prime concern here about accountability and, you know, who's responsible for what in terms of these PEPUDA changes. Take us a bit into that.
Yes. So there's two changes that really concern me. The one is that this new amendment basically eliminates the requirement of intention. So you don't have to intend to discriminate against someone anymore. It can be by accident or by a joke or by saying something silly, or just if someone takes offense to something. So that is a bit concerning. But the other one is that this bill makes corporations jointly and severally liable. So if an employee is offended by another employee, that employee can choose to sue the employee who offended them or the corporate who employs that employee. So corporations could be liable for sort of something that their employees don't even intend to do. And I think that's just seriously worrying, because it's such a stringent regulation on the private sector. And
I think on basic freedom, right? I mean, but part of what the law should be about is, actual accountability. Is the people who transgress must be the people who receive the punishment. And there's a whole discussion about whether punishment should be retributive, rehabilitative, symbolic, what that is. But part of the rule of law is that responsibility for your actions. And I must say that it is a very concerning thing, because this really starts to dismantle that. And that first point you make, I think people should realize how fundamentally radical that is. If in any sort of existing common law tradition, you do not have intention, that changes your culpability, or the extent to which you can be held liable or responsible. But the fact that you can now here be unintentionally busy with some sort of contravention of the law is, I think, massively problematic. And I must say, one thing that really grinds my gears about this thing is it smacks of the social engineering. Good laws protect freedom by saying, right, here's freedom, let us encircle it to protect it against inappropriate or destructive or bad behavior that the whole society can agree on would be detrimental to freedom. However, these new changes flips that on its head to no longer be about restricting bad behavior and making sure that freedom has the organic room to perform and to do its thing. This is now starting to look like social engineering, where the government is no longer saying, do not do this, but they are actively saying, start doing this or else. It is starting to use the law to change the behavior, not to protect something, but to push a very specific agenda. And I mean, that really creeps me out. These two things, these three things actually: accountability, intention, and the idea of protecting freedom of what the law should be in terms of inappropriate action or behavior. These things are now being tampered with to a significant extent. And Ben, any last remarks? Perhaps what's the purpose of these three letters we've written? Have we now written these letters, and are we going to sit back and say, Fan Justice Project, job well done? We haven't actually changed anything, but yeah, we wrote letters.
We're expecting a response from the department, and hopefully some accountability on their side to say, all right, we see that this is worrying to members of the public. Maybe we should extend it, release a socioeconomic assessment, actually look into what this might do to the people of this country. So yeah, we're hoping that it will increase accountability on the government side.
And when Fan Justice is out there protecting your freedom, what we always try to do is think a few steps ahead, because I mean, otherwise our enemies are really, or the enemies of freedom, I should say correctly. We can't claim to be the manifestation of freedom in perfect platonic form. But the point of writing these letters is to lay the groundwork to make sure that later on, if we decide to take aggressive legal litigation action on this, we can say to the court, yo, court, we tried to stop this very early on. We're not just jumping on this as a juicy issue late in the day. We've been involved from the start, and we've got the receipts to prove it. So we've written those letters, we've warned the department, we are monitoring the situation closely, because at Fan Justice Project, we will fight for your freedom, because your freedom is worth fighting for. Ben, thank you very much. You at home, listener, or in the car, wherever you are listening or watching this, let's not be determinist in terms of where people get their fan content. Thank you for joining us. We will see you next week to take you deeper into the fight for freedom in the courts and the corridors of power. And never forget, your freedom, well, it's worth fighting for, and we're fighting for it. Thank you very much.